As far as this topic is concerned, I must say there is a journey. And this journey was started from 2018 when this concept was introduced. And that journey has its lifespan up till 14th of October 2025, wherein one of the mode of selling a corporate debtor or its business as a going concern has been recently omitted from the liquidation regulation. But now it is very important for us to understand that is this concept is completely out as far as the liquidation order is passed, because still we have an option with the liquidator to sell the corporate debtor by the way of slum sale. Now there were two things which has been deleted or omitted, I can say, with effect from this 14th of October 2025. One is selling the corporate debtor as a going concern. That is one aspect. And second one is selling the business of the corporate debtor as a going concern. This is second aspect. In the former aspect, the entire company is being acquired by the acquirer, a bidder or a successful bidder who got the final sell certificate in his name as far as the corporate debtor is concerned. So he is getting the ownership over the company's asset and liability. But as such, very debatable part it was, just like the CIRP, this tool was being utilized by the person who was intending to acquire the corporate debtor but has failed to get his resolution plan approved, or else has not participated in the CIRP proceedings, or else identified all the valuation aspect from the CIRP proceedings and have got the best bid by the way of selling or during the course of selling the corporate debtor as a going concern. So it do have some lacunas as well, because the way these companies were being sold as a going concern and the relief and concessions which were being granted by the adjudicating authority, it was parallelly running with the CIRP. So, upon unsuccessful completion of the CIRP process, the corporate debtor was sold as a going concern before the liquidator sell out the companies piecemeal asset, or the asset wise sell take place. Before that, there was an attempt to sell the company as a going concern or selling the business of the corporate debtor as a going concern, so that the only shell of the company which remains with the liquidator, that is ordered for the dissolution. So I must say that with certain thought process it was introduced. We will be discussing this as well. Through that GRE Coke order which was passed, this concept was brought in. So it is 2018, the concept of GCS, which was brought in by the NCLT Kolkata bench by its verdict in the case of Gujarat NRE Coke. So, how this concept was brought in? What was the idea of bringing this concept of selling the corporate debtors going concern? Is it a new concept, or it was in existence much prior to 2018 amendment? That is one aspect. And today, when we say that that provision of section 32A, which has deleted both the subsection 32 subclause E and 32 subclause F, wherein it is omitted to sell the corporate debtor as a going concern or selling the business of the corporate debtor as a going concern. So, what the remedies available with the liquidator if there is a possibilities of selling the corporate debtor as a going concern, how that slum sell may help the liquidator out by opting for the same route to give a positive exit to an entity, or by bringing or to take the benefit of whatever life available in the corporate debtor before it formally get dissolved, or to avoid that dissolution order to be passed by the adjudicating authority. I believe the foremost efforts, this all is basically the point of discussion when a resolution plan is about to be placed before the committee of creditor for its approval. And when the COC is of that opinion that if no resolution plan, let this corporate debtor be ordered as liquidation, or liquidation be ordered for a corporate debtor. And at that stage, this concept of selling the corporate debtor is a going concern, which always spikes. I always hold this opinion that this should be the very foremost effort, and this is all my viewpoint. It has never been deliberated, discussed, or never been a part of any discussion paper as well. But I strongly believe that the life of the company or the company will get its maximization of its value when that CIRP trigger, and gradually the valuation keeps on changing down, or it is the valuation keeps on getting impacted badly over the period of time when the CIRP continues and when CIRP moving towards a liquidation. And I believe that why this should not be opted as a first rescue treatment rather than waiting till the CIRP to get ended up unsuccessfully. So the views may differ, the opinion may differ, but certainly we need to check that how the concept was introduced, why the concept was introduced, and what is the logic and what was the idea of insolvency law committee to invite on a discussion paper the views of the stakeholder prior to omission of this clause E and F from regulation 32. So we will be discussing the same in detail, but I would like to invite your views in case if any, because the participants are all the insolvency professionals and they must be practicing in this arena of liquidation or the CIRP. And I will invite views if any, just a viewpoint from you in addition to this particular fact that today, even though subclause E of regulation 32 and subclause F of regulation 32 has been omitted, I'm talking about liquidation regulations, but still there is a hope, there is a possibility, and we have a firm belief that if there is a life in the corporate debtor's heart or soul, then still this can be possible, wherein the accumulated asset and liability or identified asset and liability can be sold out, and the corporate debtor can be sold out to a willing acquirer or to a successful acquirer, through which it can avoid the consequences of getting dissolved. So I just want to have the views before I formally start with the content, whatever is available by the help of website of the IBBI, their discussion papers, the regulations and the code. So in case if there is any view before we initiate the things, I'll invite, otherwise we can start with the regulation itself. So foremost, I would like to touch upon the code itself, and that is section 20 of the code. And this is there on the screen. Of course, this is the intent, that is the maximization of the value of the asset. And when we say maximization of the value of the asset, you can get the maximum value of the asset of the corporate debtor when the insolvency get triggered. And you cannot hope and you cannot expect the similar valuation to keep or to have the valuation intact even throughout the process of CIRP or even upon unsuccessful end to CIRP. And that's why I always believe that why this sell as a going concern is not considered as a paramount effort of the IRP or RP, and why this is left for the liquidator or the COC or the adjudicating authority to decide as a last resort. That is all my, it's a point of, you can say, an argument, or it's a point of my opinion, which may have a considerable value, may not have. But yes, I would like to first touch upon section 20, because section 20 talks about that efforts of the RP or the IRP is to keep the corporate debtor as a going concern. And to keep the going concern, there are multiple things which are there in the code itself, which may assist RPU during the course of CIRP, wherein you can keep the life of the company, a corporate debtor, intact before it actually dies through a formal order of liquidation or the dissolution at the end. So it is an IRP, and this is not from the RP. I must say, from the very beginning, it is the IRP who shall make every endeavor to protect and preserve the value of the property of the CD and manage the operation of the CD as a going concern, which is very less likely to happen. Because once IRP is appointed or the RP is appointed, the timeline, it is very stringent. Though the timeliness have been now be considered as a not mandatory and recommendatory, but otherwise as well, his job is to just see what are the steps to be taken care of: inviting claims, verification of claim, constitution of committee, appointment of RP, asking for the valuation of the asset, getting the valuation report, preparation of the IM, inviting EOI. So he gets too much occupied. It's very difficult for this person known as an IRP to make an effort to see the operations or the management of the affairs of the company as a going concern. But this is what our cold prints talks about. For the purpose of subsection 1 of section 20, the IRP shall have the authority. Now, he do have this power to appoint accountants, legal or other professional as the case may be, and this is all the cost of the CIRP. To enter into a contract on behalf of CD or to amend or modify any contract or transaction which were entered into before the commencement of CIRP. This is again a power, but with a single intent, that is to keep the corporate debtor life intact, which always gets diminished once it is publicly known to the stakeholder that this company is in CIRP. This is very important aspect to raise interim finance, but the provider of this interim finance are not in plenty. Provided that no security interest shall be created over any encumbered property of the corporate debtor without the prior consent of the creditor in whose debt is secured over such encumbered property. Very natural it is. So if you are creating a security over a property which is already subject to the charge, you have to take the prior approval of the lender in whose favor that security is created over that property. Provided no prior consent of the creditor shall be required in case if the value of the property is not less the amount equivalent to twice the amount of the debt. So in that case, it is not required. If the amount secured by the way of creating security over that asset and the valuation of the asset is not less than amount equivalent to twice the amount of debt, to issue instructions to the personnel of the CD as the case may be for keeping CD as a going concern, but it is very harsh and it is very difficult. On the one side, the code talks about seeking necessary assistance from the management, getting necessary assistance from the management to refer management to assist IRP and RP during the course. But it is the job of the IRP and IRP to collate the data from the management and to go against the management by the way of making an application under section 43, 44, section 66. No management is going to give the data and information which is going to be utilized against the same management to take all the action as may be necessary to keep the corporate debtors going concern. Now, section 20, and this section 20 is basically having its reflection in the preamble of the code itself. Because all the efforts this IRP or RP has to make so that during the course of CIRP, the life should not get deteriorated or the valuation should not get impacted, but it is bound to happen. If CIRP will continue for an extended period, this is bound to happen that valuation of the company's asset is going to be impacted. Now, this is just the introduction with the code. I would like to refer to that CIRP regulation. Now, this is the IBBI Insolvency Resolution Process for Corporate Debtors Regulations 2016. And in this, we have Regulation 39, that is BA 39C and Regulation 40D, which very well talk about that what COC has to consider when they are thinking for a liquidation order to be passed by the adjudicating authority instead of considering any resolution plan which is tendered by any resolution applicant. Let's have a look on regulation 39B, and we are dealing with IBBI Insolvency Resolution Process for Corporate Persons Regulations 2016. But this is not the amended portion we are discussing. I'm discussing the things prior to 14th October 2025. Now, when you see this regulation, this 39BA is relevant. Now, here it is. It's very important, and there is a scope wherein you can still have the option to enter into a scheme of compromise and arrangement, what we have under the Companies Act section 230. And if you are entering into a compromise and arrangement with the creditor or its class, member or its class, by way of proposing a scheme of amalgamation of a corporate debtor with any other entity who is intending to propose the scheme. So you need to refer the provision of section 230, section 232 in this regard. But this is regulation 39BA, which talks about while deciding to liquidate the CD under section 33, which talks about a dissolution or so winding up order to be passed by the adjudicating authority. So while deciding to liquidate the corporate debtor under section 33, the committee shall examine whether to explore the compromise and arrangement as referred under subregulation 1 of regulation 2B of the liquidation regulation, and the resolution professional shall submit committee's recommendation to the adjudicating authority while filing application under 33. So when an application will be made before the adjudicating authority for seeking an order of liquidation, it is the COC who has to place its suggestion, or it's a committee of creditor who need to put his recommendation regarding this compromise and arrangement. Where a recommendation has been made under subregulation 1 of regulation 39BA, the resolution professional and the committee shall keep exploring the possibility of compromise and arrangement during the period the application to liquidate the corporate debtor is pending before the adjudicating authority. So committee shall keep on exploring the possibility of compromise and arrangement during the period the application to liquidate. So here it's not 66% voting share which is going to help you out. Now you need to straight away refer to that compromise, arrangement and amalgamation rule under the Companies Act, that is 2016 rule, which talks about separate meeting of the members to be called, separate meeting of creditors to be called. Their approval is required by the way of who are representing majority in number holding 3/4 in value. So altogether a different permutation and combination, wherein if the resolution plan has been approved by the committee of creditor holding 66% voting share, straight away if this is being proposed or if this is being planned or if this being suggested or if this being recommended, then in that circumstances it is not the IBC code on the basis of which the compromise and arrangement will be proposed and it will be approved by the adjudicating authority, but here the approval will be of the creditors, and creditors are of each class. So unlike the dominance of financial creditor in COC, there is no such dominance of financial creditors only, because there will be a separate class of creditor which will be divided amongst secured and unsecured, and in the unsecured every creditor will be classified, be it a financial and operational. So that is altogether a different rules under the Companies Act which deals with compromise and arrangement. But here it comes our topic, regulation 39C. I'm talking about how it was introduced. There was an idea behind this introduction. 39C. While approving a resolution plan under 30 or deciding to liquidate CD under 33, committee may recommend that liquidator may first explore the sale of the corporate debtor as a going concern under clause E of regulation 32. That is of the liquidation regulation, IBBI liquidation process regulation, or sell of the business of the CD as a going concern. So there is a difference. Selling of the corporate debtor as a going concern, that means the entire entity will be acquired by the acquirer. Whosoever is going to be my successful bidder is going to acquire the entire entity. So the company will be out from this CIRP or will be out from the liquidation, wherein it is also stated that the committee may also recommend the liquidator that liquidator may explore this possibility as well. That is selling the business of the CD. So when I say business, it is the asset and liability and not the CD by its corporate identity of its own. So CD will be dissolved, but asset and liability will be sold out. So it may be equated with the slum sale as well if an order for liquidation is passed. So this is something which is very important, and this is how the COC assess. I'm repeating for the sake of, again, for the assistance to all the participants or for the sake of their convenience. We are on regulation 39C and we are discussing what was the intent of the government to bringing this going concern regulation, and what were the intentions or what were those reasons or what were those rational or what was those encouragement to omit out such kind of regulation, that is clause E and F. So while approving a plan under 30 or deciding to liquidate the CD, because when COC is sitting, they always see the equilibrium side, whether to opt for a resolution plan's approval or whether to decide that this company or this corporate debtor to be ordered as liquidation. So while approving a resolution plan under section 30 or deciding to liquidate the CD under 33, the committee may recommend that liquidator may first explore the sale of the CD as a going concern under clause E of regulation 32 of the liquidation process regulation, or liquidator may first explore to sell the business of the CD as a going concern under clause F if an order for liquidation is passed under 33. अगर liquidation का order pass होता है तो where the committee recommends sell as a going concern, so it shall identify the group of asset, but there is no purpose, then entire asset will be sold out. So when the committee recommend the sale of the corporate debtor as a going concern, it shall identify the group of asset and liability which according to the commercial consideration ought to be sold as a going concern under clause E or F of the IBBI liquidation process regulation. The resolution professional shall submit recommendation of the committee under regulation 1 or 2 to the adjudicating authority while filing for the approval or decision of the committee under section 30 or 33. So basically, whatever viewpoint which has been decided and placed by the committee, it shall be placed before the adjudicating authority while filing an application for the approval of plan under 30 or filing an application for liquidation of the corporate debtor. So it is the COC who used to measure or who used to identify or used to evaluate that what liquidator, in case of the liquidation order is passed by the adjudicating authority, then adjudicate that then the liquidator has to first explore the possibilities, if any, with regards to the sale of the asset and liability of the CD as a going concern or the business of the CD as a going concern. Now, this is regulation 39C. And when you see regulation 40D, it is again having a reference to a going concern. This is the decision of the liquidation or decision for the liquidation. The committee, while considering the liquidation of the CD, committee, while considering the liquidation of the corporate debtor, may consider the factor but not limited to non-operational status for preceding 3 years. So what committee is going to consider while deciding that whether the liquidator should explore the possibilities of selling the CD as a going concern or selling the business of the CD as a going concern? So debtor may, the liquidation of the corporate debtor, committee, while considering the liquidation of the corporate debtor, may consider the factors including but not limited to non-operational status for preceding 3 years, good produced, service offered, or technology employed being obsolete, absence of any asset, lack of any intangible asset, or factor which bring value to the going concern over and above the physical asset, like brand value, intellectual property, accumulated losses, depreciation, investment that are yet to mature. So basically, these are the factors, and this is what the provided that the committee, while deciding about the said factor, will not only consider that views limited to this aspect only. Again, I'm reading that the committee, while considering the liquidation of the CD, may consider the factors including but not limited to non-operational status, goods, or about the services or the technology which is obsolete, or absence of any asset or lack of any intangible asset, or factor which bring value as a going concern over and above the physical asset, like brand value, intellectual property, accumulated losses, depreciation, investment that are yet to mature. And when we see the liquidation regulation, when we see the provisions of the liquidation regulation, and that is again very relevant, regulation 32, the methods which are available or the modus which are available with the liquidator, in what manner it is going to be sold out or the assets are going to be disposed of. Regulation 32. Now, this is very relevant. Now, realization of the assets, regulation 32. and that talks about the liquidator may sell an asset on a standalone basis. But this is all after the failure of all the efforts of selling the CD as a going concern. Then he may sell the asset on standalone basis, slum sell. And fortunately, that slum sell option is still available with the liquidator, through which the corporate debtor can be sold in a very similar fashion, even though this omission of clause, that is subclause E and subclause F to regulation 32. So assets on a standalone basis, it can be sold. Assets can be sold in a slum sell. Assets, sets of assets collectively can be sold. Assets can be sold in parcels. I don't feel that on a standalone basis or in parcel there may be any difference, but these were the two clauses which were inserted. There's two clauses which were inserted, and that is October 2018 I'm talking about. It was 22nd of October 2018 when this clause E, subclause E and subclause F to regulation 32 was inserted. The corporate debtor as a going concern. So liquidator may sell the entire corporate debtor as a going concern. So no shell will remain left. It is the entire company which will be sold with assets, with liability, as is where is basis. It will be sold as a going concern, and the status of the company will be changed from under liquidation, because this happens once the liquidation order is passed and it is triggered. This is what you can see from the regulation itself, that how this is compromise and arrangement. Have a look on it. Where a compromise or arrangement is proposed under section 230, it shall be completed within 90 days of the order of liquidation under section 33, provided that a person who is not eligible under the code to submit a plan, he cannot be a person who can propose this kind of scheme of compromise and arrangement. Very natural that the liquidator shall file the proposal of the compromise and arrangement only in case where the recommendation has been made by committee, what we were reading 39BA. The time taken on compromise and arrangement not exceeding 90 days shall not be included in the liquidation period. That is all one part. So this is all the initial effort, that how and what efforts this liquidator generally put in to safeguard the corporate debtor from being liquidated. And this is a part of the liquidation process regulation, which talks about how the corporate debtor will be, or how the liquidator may deal with the asset of the corporate debtor. So realization of the asset, the provision, or rather calling provision a regulation which is relevant, that is regulation 32, where it is stated that the liquidator may sell the asset of the corporate debtor on a standalone basis. Liquidator's asset can be sold out as a selling a corporate or selling any undertaking, a slum, by the way of slum sell. We used to enter into a business transfer agreement, BTA. Selling the assets collectively or selling the assets in parcel, corporate debtor is a going concern, or the business of the corporate debtor is a going concern. Unfortunately, both the subclauses E and F to regulation 32 is deleted, omitted with effect from this October 14, 2025, 3 months back. Provided where an asset is subject to any security interest. This is the biggest, you can say, hurdle. Because when a liquidator is intending to sell the corporate debtor as a going concern, or selling the business of the corporate debtor as a going concern, but if there is a security interest created over the asset of the corporate debtor in favor of any creditor, then if that creditor do not want that asset to be a part of the liquidation asset, this is going to be you can say a fail efforts. This is not going to be a successful attempt, because when a secured creditor don't want to relinquish that security interest and don't want that asset to be a part of the liquidation asset, then he want to deal with that asset independently. And if they want to deal with the asset independently, you cannot sell out the corporate debtor as a going concern in that case. So where an asset is subject to security interest, where an asset is subject to any security interest, it shall not be sold under any of the clause A to F unless a security interest has been relinquished to the liquidation estate. So he's always having this option available under section 52. He may either relinquish or he may either deal with the asset, a secured asset, as per the rights available. So, in case if the asset is subject to any security interest, it shall not be sold under any of the clause A to F unless the security interest therein has been relinquished to the liquidation estate. Now, this is regulation 32A, which was dealing with selling as a going concern, where a committee of creditor has recommended sell under clause E or F, that is, selling the corporate debtor as a going concern or the business as a going concern, or where the liquidator is of the opinion that sell under clause E or F of regulation 32 shall maximize the value of the corporate debtor, he shall endeavor to first sell under the said clauses. Of course, the purpose is going to be defeated if this all have been opted initially. Bachega kya? Nothing will be left out if this can be some of the assets have been sold on a standalone basis, or slum sell of some asset, or the liability has taken place, or the sets of assets collectively have been sold, or in parcel it has been sold. And that's why, to maximize the value of the corporate debtors available asset, it is very clearly stated under regulation 32A, where the committee of creditor has recommended sell under clause E or F of regulation 32, or where the liquidator is of the opinion that sell under clause E or F of regulation 32 shall maximize the value of the CD, he shall endeavor to first sell the said under the said clauses. When you see subsection sub-regulation 2 to regulation 32A, for the purpose of sell under subregulation 1, the group of assets and liability of the corporate debtors identify the committee of creditor under subregulation 2 of 39C of the IBBI, which we were dealing of insolvency resolution process for a corporate person, shall be sold as. So they need to identify, the committee has to identify the group of asset and liability of the CD that need to be identified the committee of creditor under sub-regulation 2 of that 39C of the IBBF CRP regulation, which shall be sold as a going concern. Where the committee of creditor has not identified the asset and liability under sub-regulation 2 of 39C of CRP regulation, it's a liquidator who shall identify the group of asset and liability to be sold as a going concern in consultation with the consultation committee. The liquidator may sell the assets of the corporate debtor under clause E of regulation 32. The liquidator may sell the assets of the corporate debtor under clause E of 32 exclusively only at the first auction. So it is very, very important, and which was later on introduced in 2022. It was in 2022 which was introduced on 16 on the 16th of September 2022, where it is stated that liquidator may sell the asset of the corporate debtor under clause E of regulation 32, and E talks about selling the corporate debtor as a going concern exclusively only at the first auction. So when you will be facing the first auction, it is stated that it's a liquidator may sell the assets of the corporate debtor as a going concern, the entire assets and liability under clause E of regulation 32 exclusively only at the first auction. And the explanation to this fact is very clear that for the purpose of subregulation, it is clarified that sale of the corporate debtor under clause E, that is sale of the corporate debtor as a going concern, cannot be offered as the only option for the bidder at the first auction. So this cannot be offered as the only option for the bidder at the first auction. You can give them the options as well. So for the purpose of this sub-regulation, it is clarified that the sale of the CD under clause E of regulation 32 cannot be offered as the only option for the bidder at the first auction. But it is clearly stated that if you are selling the corporate debtor as a going concern, that at the first auction you should place it before the intending bidder to bid for the entire company. So may sell the assets of the corporate debtor under clause E of regulation 32 exclusively only at the first auction, but bidders will be having this choice to acquire the assets which they are desired to acquire for. So for the purpose of this sub-regulation, it is clarified that the sale of the corporate debtor under clause E cannot be offered as the only option for the bidder at the first auction, after the first auction. When the liquidator is of the opinion that it is viable to run the CD as a going concern, he shall consult the consultation committee, and only on its advice he shall run the affairs of the corporate debtor as a going concern, which is rarely going to happen, because already the corporate debtor is passing through a rigorous process of CIRP. The CIRP is failed attempt, and still if the and because if it would have been a going concern, this CD must have received the resolution plan, a successful resolution applicant as well. So it is just stated that liquidator is of the opinion that it is viable to run the CD as a going concern. He shall consult the committee, that is consultation committee, and only on its advice he shall run the affair of the corporate debtor as a going concern to the extent possible. Now this is how, and this is what basically the introduction of this regulation was. So how it was introduced and with what intent is it was introduced. I'm also sharing with you that there is another. So before it brought in as part of the liquidation regulation, what was the idea or what was the ultimate intent of the IBBI was, and later on they have removed with what intent. Now, this is what the ultimate intent of the government of bringing this in as a part of the liquidation regulation, so that the corporate debtor may realize its value or maximize its value. This is an amendment to the IBBI liquidation process regulation, and I'm talking about how it was introduced as a part of this 2018. If I just give you a background, before 2018, there was no concept of going concern sell in IBC. It was 11th of Jan 2018, the concept of going concern sell. It was by the NCLT Kolkata bench in the matter of Gujarat NRE Coke. I'm talking about 22nd of October 2018, when the going concern cell was introduced as a part of Regulation 32E, which we were discussing about. Regulation 32E, selling of the corporate debtor is a going concern, or the selling of the business of the corporate debtor is a going concern. It was 25th of July 2019, Regulation 32A, providing clarity to that GCS, which we were reading. 16 September, which we recently read, inserted restriction of going concern sell option only as a first auction. In the first auction, you will be giving this opportunity to the bidder, wherein any of the intending bidder may acquire or may bid for the corporate debtor as a purchasing the corporate debtor as a going concern. But very recently, unfortunately, Feb 2025, year back, there was a discussion paper which we are going to read out regarding the omission of the going concern cell from the liquidation process regulation, and with effect from 14th of October 25, it was the going concern cell omitted from the liquidation regulation. It was the IBBI liquidation process second amendment regulation 2025, due to which there is an omission of regulation 32E and clause F of regulation 32, which has been omitted from the liquidation process regulation. But let us have a look that what was the positive idea of the government and how that idea was not up to the mark as far as the government intent was concerned, and how later on it was a part of the discussion paper, the views were invited, and how it was omitted. So in the matter of Gujarat NRE Coke Limited, after the failure of the resolution, even during the extended period, the adjudicating authority appointed the RP as a liquidator. An affidavit filed by the workman and employee emphasized that the regulation provide for a slum sell of the asset, and therefore permitting the sell and therefore permit the sale of the business of the corporate debtor, including all its asset and property as a going concern. And Honorable Supreme Court and High Court have often directed sale of the asset of the company as a going concern to prevent employment, particularly where the corporate debtor is going concern. If you can see the language of the adjudicating authority, accordingly, the adjudicating authority directed the liquidator shall try to dispose of the CD as a going concern after publication of notice in the newspaper with the reserve price, which shall be equal to total debt amount including interest and maximum period applicable for trying the sale of the CD as a going concern, which will only 3 months from the date of order. If the process of the sale as a going concern failed during this period of 3 months, then process of sale of the asset of the company will be according to the provision of the sale of the asset, which is prescribed in the liquidation process regulation. In case it is not concluded within this period of 3 months, the order of this court directing the sale of the company as a going concern set aside, and the corporate debtor be liquidated in a manner laid down in Chapter 3 of the liquidation process provided in the code. So, this is how first the order was passed and later on it has become a part of the regulation. However, the sale could not happen. Application was filed under section 230 to section 232, that is compromise and arrangement, for obtaining the sanction of the NCLT to the scheme of compromise and arrangement between a petitioner and secured creditor FCCB holders, shareholder of the Gujarat NRE Coke. NCLT passed an order directing separate meeting of the shareholder, FCCB holder, secured unsecured creditor to consider and if thought fit to approve with or without modification the scheme of compromise and arrangement. So it was proposed, but the sale could not happen. And thereafter, it was section 230 with section 232, which was proposed before the NCLT regarding the scheme of compromise and arrangement between a petitioner, secured unsecured creditor, FCCB holder, and shareholder of the Gujarat NRE Coke Limited. Now, see, the key benefit of selling the corporate debtor as a going concern in liquidation, as against the other manner of the sale, it can preserve employment, but hardly in case if the entity is running, while maximizing the return for the stakeholders. But I've seen many non-operative entities are being sold in this fashion. Many viable companies may end up in liquidation in absence of availability of the adequate number of the bidder in the market, or non-approval of the plan by requisite voting share of its financial creditor, or other reasons. Liquidation of such company may be premature and can result in avoidable loss of employment, critical disruption of the trade creditor who are dependent on the enterprise for revival, reduction in returns for secured unsecured creditor and other stakeholder, loss of revenue to the government due to drying up of the collection of tax and other revenue from enterprise, and there is a merit in attempting the sale of the corporate debtors going concern. So this was the ultimate idea. This was basically an overall idea leading to which that going concern sale was introduced. What was the idea? Idea of the government was many viable entities may end up in liquidation in absence of the availability of the adequate number of bidder in the market or non-approval of the plan. But hota ye raha, a non-operative entity having no assets, no liabilities are also being sold as a going concern. So bidder is the only person getting benefited out of it. And it is realizing much lesser value than what the liquidation would have been realized. Liquidation of such company may be premature, but the problem is here the expired entities are also have also being sold as a going concern. Avoidable loss of employment, okay, critical disruption of the trade creditor who are dependent on the enterprise for the revival. An entity which is itself per se it is not viable and having no possibilities of stand by itself. If the entity is of that nature wherein it may give some age to the business or age to the business of some other enterprises who are dependent upon this corporate debtor for its survival, then the case is different. Reduction in return for secured, unsecured creditor and other stakeholder, loss of revenue of the government due to drying up of collection of tax and other revenue from enterprise. There is a merit in attempting the sale of the corporate debtor as a going concern in liquidation process. So this was the idea, or this was the rationale for bringing this concept under regulation 32 by bringing clause E, by bringing clause F, that is selling the CD as a going concern or selling the business of the CD as a going concern. As stated in the status note of the CIRP, relatively more corporate debtors are ending up in liquidation. Though this is for legacy reason, it is important to avoid liquidation. In fact, The recent ordinance explicitly promotes a resolution over liquidation. Regulation 32C aimed to save a company from liquidation. Even through CIRP has failed to yield resolution. It read as 32, and that is what we have read as well. The liquidator may sell an asset on standalone basis, or sell the asset in slum sale, or collectively or in parcel, or the corporate debtor is a going concern. One roundtable was held with the stakeholder on May 18, and it was basically October 18 when GCS introduced Regulation 32E. October 18. So there was a roundtable with the stakeholder on May 18 to understand difficulty in selling the corporate debtor as a going concern. Several challenges were brought up. 52 read with 33.5 allow, and this is very difficult issue. Secured creditor an option to relinquish security interest to the liquidation estate and receive proceeds from the sale of the asset by liquidator in a manner specified in 53, that is waterfall, or realize its security interest in a manner specified in 52. Thus, a secured creditor may opt to realize its security interest outside liquidation, foreclosing the option of the sale of the corporate debtor as a going concern. Yes, that was a challenge. And in order to sell the corporate debtor as a going concern in liquidation process, either the secured creditor has to opt in favor of relinquishing the security interest in favor of the liquidation estate, or the secured creditor postpone exercise its option under 52 to realize security interest outside liquidation process to allow liquidator to explore possibility of selling as a going concern. So that was a challenge, and that is a challenge as well. A very good one to understand the mind. We are reading the mind of the government, that how the mind shifted from this 18 to 2025. I would like to read up again that a roundtable in 50 in May 18, and just to discuss what are going to be the practical teething problem in case of selling the CD as a going concern, and several challenges were brought up, and this is going to be the key issue: secured creditor, because the code allows secured creditor an option to relinquish security interest. It's good if he is relinquishing the security interest to the part of the liquidation estate and receive the sale proceeds under section 53 in priority of section 53, or he do have this power as well to realize its security interest in a manner specified in 52. And thus, when a secured creditor opt to realize its security interest outside the liquidation, then it will foreclose the option with the liquidator to sell the CD as a going concern in liquidation process. Either the secured creditor opt in favor of relinquishing the security interest in favor of liquidation estate, or secured creditor either postpone to exercise this option under 52 to realize security interest outside the liquidation process, which may allow the liquidator an option to explore the possibility as a going concern sell. Further, the liquidation is the process that entails disposal of the asset of the entity. A liquidator does not run the company, and this is a very hard fact. He does not run the company. His task is to liquidate. Though the law has always empowered the liquidator to carry on the business of the company to the extent required for beneficial liquidation, the liquidator may do only such things and carry only those activities which are conducive to liquidation. 33.7 mandates that order of liquidation under this section shall deem to be a notice of discharge of the officers, employees, workmen of the CD, except when the business of the CD is continued during the liquidation process. So basically, once the liquidation order is passed by the adjudicating authority, it is deemed to be a notice of discharge to the employees, officers, and workmen of the CD, and they will only continue when there is a possibility is that the business of the CD is continued during the process by the liquidator. Going concern means all the assets, tangible, intangible, and as I said, everything in the company and the resources needed to continue the operate independently. A business activity which may be whole or a part of the business of the CD without individual values being assigned to it. In view of this, the following options are submitted for consideration. Let's see. Corporate debtor may be sold as a going concern as provided in the extent regulation. As the company survives, there will be no need for a dissolution. As I said, when you are selling the entire company as a going concern, there is no question of dissolution, because then the company will survive and will company will be out from the status of under liquidation. The assets, along with all attendant claim, limitations, license, permits, business authorizations, remain in the company. The company survive as it was. The ownership of the company will be transferred by liquidator to the successful acquirer. The liquidator shall make an application to AA for approval of the sale of the corporate debtor as a going concern, and the adjudicating authority may pass order with respect to sale of the CD to intended buyer, transfer of the share of the CD to intended buyer, continuation of the authority power obligation of the liquidator to complete the liquidation process as provided in code and regulation, including control, operation, and continuation of the liquidation bank account of the corporate debtor, payment to the stakeholder in accordance with 53 from the liquidation bank account, protection of intended buyer from all the claims and liabilities pertaining to prior period, just like CIRP. Protection of the, this is something which was a part, or which was a part of discussion. Protection of the intended buyer from all claims and liability pertaining to the prior period of the sale of the corporate debtor is going concern. In such case, the final report of the liquidator as required under clause 3 of regulation 45 shall form a part of the application for closure of liquidation process of the corporate debtor and not for dissolution of the corporate debtor. The regulation may provide, ये तब की बात है when it was not a part of the regulation. So this is a part of regulation with effect from this 2018, 22nd October, not prior to that. The regulation may provide another option for sale, that is sale of the business of the, now this is another thing. Regulation may provide for another option of sell, and that is a sale of the business of the corporate debtor as a going concern. In this particular case, what will happen? The assets and liability will be sold out, and not the corporate status itself. So the corporate status will remain a shell, and then the liquidator will make an attempt to dissolve that entity by the formal order of the NCLT. So it will be only the sale of the business and not the corporate debtor per se, which will be liquidated in accordance with the regulation. In this case, the assets and liability relevant for business will be transferred to a new entity. The stakeholders are paid from the proceeds of sale in accordance with 53, and the corporate debtor will be then dissolved by the order of tribunal. This is another option. जो रेगुलेशन 32F में, रेगुलेशन 32 क्लॉज F के जरिए जो आया, सेलिंग ऑफ द बिजनेस ऑफ द कॉर्पोरेट डेटर इज गोइंग कंसर्न. The regulation may provide for another option for sale, that is sale of the business of the corporate debtor is going concern. It will be only sale of the business and not the corporate debtor, which will be liquidated in accordance with the regulation. So assets and liabilities जो है, that will be acquired by the bidder. Sale proceeds will be utilized for the payment of the liability. In this case, the assets and liability relevant for the business are transferred to a new entity, and the stakeholders are paid from the proceeds of sale in accordance with 53. And finally, the only shell, the body wherein the heart has been sold to the acquirer, the only structure or skeleton which will be ordered as dissolved by the adjudicating authority. So both the options require consent of secured creditor to relinquish security interest. If security interest is not relinquished, the other mode of sale will be used. So this is what sent for the consideration for governing body. This was the idea, basically. This was the idea. So idea was not successfully implemented, and it has now, just I've seen in every CIRP, section 43, section 66 application has been now put as a part of the mandatory required. It's not mandatory. It's absolutely not mandatory, and this is quite surprising to see the auditor of the company who was there with the company prior to CIRP, the same auditor is being continued, and now the same auditor is now questioning those transactions, the transactions which was there within his lens when he was the auditor of the company. Now he is identifying few firms of a chartered accountants, a forensic auditor, who are conducting the forensic audit, transactional audit. It's not required everywhere, and it's not mandatory that this has to be done. One has to frame an opinion before jumping to this conclusion. Similarly, this was made as a part of the routine process that if the CIRP has been successfully ended up with, now this is not a concern, but in case if the no resolution plan has been come forward, or in case if the no resolution plan was put forward by the COC to the adjudicating authority, then in that circumstances, it is always the liquidator who used to make his efforts or make all his attempts to sell the company as a going concern, in spite of the fact that company do not have any asset or do not have any receivables, or company do not have any kind of you can say resources through which it can be effectively continued, or it can be effectively revived. Many of the companies are basically, they deserve to pass through that liquidation process, because they are the entity who are only ultimately deserving the dissolution order to be passed by the adjudicating authority, and there's no scope left for those entities to get up on its own fit, even through by the help of some bidder. Because when company do not have any asset, and even a bidder is aware of this fact that this asset is having no, it's only a paper asset, or it is only a asset available on a paper, otherwise there is no idea about the whereabouts of the property, and still these companies are being sold out, and it is realizing no value, no creditors are being benefited, but still this process is being opted for. Many times this process may ended up successfully, many of times this process may not ended up successfully, and that just add a cost to the liquidation process, a liquidation cost. So I believe that before we reach out to what the ultimate intent of the government through discussion paper was, I'm talking about 4th of Feb 2025 discussion paper. I just would like to have your views on it, that how you perceive or how you see this amendment of 2025 by omission of regulation 32 clause E and clause F from liquidation process regulation. Do you still believe that this, in spite of having no place in the regulation, but liquidator do have this option available because of that slum sell option, which is still a part of regulation 32, and they may still sell the corporate debtor as a going concern? I will invite and I will insist you to please bring on or put forward your views on this. Because many of you must have faced these practical difficulties, and many of you must have seen that how the COC is actually driving the entire process, and there is nothing still they are recommending that liquidator may make all his endeavors to sell the corporate debtor as a going concern before formally starting the process of liquidation. I'll happy to hear you in case if there is some viewpoint to discuss. Certainly, it will be adding a value to entire discussion. Anyways, if we see the 4th Feb 2025, and that was a discussion paper. Now, that is a discussion paper. It's IBBI 4th Feb 2025 discussion paper on streamlining the process under the code, reforms for enhanced efficiency and outcomes. So when you see the discussion paper, there were so many areas on which that discussion paper was published. And the IBBI also has also invited comments from the stakeholder on the proposal contained in that discussion paper. The discussion paper has been prepared to address various operational challenges encountered in CIRP liquidation process, insolvency resolution, and bankruptcy process of the corporate personal guarantors. The paper proposes key amendments to the relevant regulation with an aim to enhance efficiency, transparency and effectiveness of the process while providing clarity on various operational aspects, including management of essential services, coordinated resolution of the interconnected entities, streamlining of the submission of the plan. But very relevant, which we should see, is the sale of the corporate debtor as a going concern. This is very important. The Standing Committee on Finance, in its 32nd report, recommended that Regulation E, and there was no such kind of recommendation for omission of, there was no such kind of recommendation for omission of Clause F, no recommendation. The Standing Committee on Finance on 2021, in its 32nd report, recommended that sale of the corporate debtor as a going concern to be omitted. 32E of the regulation, which provide for sale of the corporate debtor as a going concern, be deleted. So there was no recommendation for clause F. And we don't know why, in spite having no recommendation, when we have seen this amendment of 2025, that liquidation process, second amendment regulation 25, both clause E and F of regulation 32 has been omitted. Further, the Colloquium on Functioning and Strengthening of the IBC Ecosystem, in its report of November 22, has also inter alia recommended deleting the provisions of sale as a going concern under liquidation. Insolvency Law Committee, in its Feb 2020 report, noted that the code provide a linear process for resolving the insolvency of the corporate debtor. First, CIRP is commenced, during which COC assess the viability of the CD and invite plan. Only where CIRP fails, the code provide for an entry to liquidation. So how the government is changing its mind? What was there in the mind of the government while putting a proposal, and what is right now in the mind of the government a year back when they come out with this discussion paper? Of course, they have seen the practical difficulties, and not only the practical difficulties, but they have also seen how this is being misutilized and how it is not adding any value to the assets of the corporate debtor. Thus, the liquidation has been envisaged as the state the entity enters at the end of the IRP, insolvency resolution process, when neither creditor nor debtor can find a commonly agreeable solution by which to keep the entity as a going concern. Therefore, entry into liquidation itself implies the inability of the CD to be continued as going concern. Accordingly, the code prescribed dissolution of the CD as the final outcome of the liquidation process. The committee also noted that if attempts for reviving the CD are undertaken after liquidation order is passed, it may lead to delays and may also undermine the efficacy of CIRP, which provides a time bound period for reviving the CD. The committee agreed that it would be contrary to the scheme of the court to allow CD to be sold as a going concern after conclusion of the liquidation process. But this is not at the conclusion of the liquidation process. This is at the beginning of the liquidation process, when liquidation per se was not started, which envisages a dissolution of the corporate entity. And accordingly, the liquidation regulation should be appropriately amended to prevent a company as a going concern. So this is what the idea, or this is what the intent. Thus, the liquidation has been envisaged as state the entity enters at the end of the IRP, where neither the creditor nor the, so now see the entire overview, or no, entire viewpoint has been changed, where neither the creditor nor the debtor can find a commonly agreeable solution by which to keep the entity as a going concern. But I believe that this should not have been omitted, and there was no harm for, when you see the ultimate reviewer or the monitor or the ultimate overseer of the commercial wisdom to be with COC, let them decide it. Therefore, entry into liquidation itself implies the inability of the corporate debtor to be continued as going concern. Accordingly, the code prescribed dissolution of the corporate debtor as a final outcome of the liquidation process, but that is after the liquidation. The committee also noted that if the attempts for reviving the corporate debtor are undertaken after a liquidation order is passed, it may lead to delay and may also undermine the efficacy of CIRP, which provide a time-bound period for reviving CD. The committee agreed that it would be contrary to the scheme of the code to allow a CD to be sold as a going concern after the conclusion of the liquidation process, which envisages a dissolution of the corporate entity, and accordingly, the liquidation regulation should be appropriately amended to prevent CD as a going concern. Regulation 32E and 32F provides that liquidator may sell the corporate debtor as a going concern or the business of the corporate debtor as a going concern. It has been observed that the outcome in the case of the sale of the CD as a going concern have been below par as compared to the dissolution. Creditor recovered only 2.4 through going concern sale, but 3.7 via regular dissolution. This indicates that going concern sale provide no additional value. So it's all a hit and miss. So government has initially decided that how this sell as a going concern may bring some value to the stakeholders. And after reviewing for 7 years from 18 onwards till 2025, how they have identified the practical issues and how they have reached out to the statistical conclusion that the liquidation value which is being realized through sell as a going concern is much less than a normal dissolution process, which generally passes through a formal liquidation process. So this indicates that going concern sell provide no additional value or prevention advantage compared to a regular dissolution. Further, the maintenance of the CD as a going concern during liquidation has led to an escalation of the going concern cost. When CD has not been sold as a going concern, it has been observed that liquidators seek various relief from the adjudicating authority while filing an application for approval of the sale as a CD as a going concern, even though the same is not contemplated in the code. This is what was happening. And this is what was there in the discussion paper when the same thing was brought in. And now the government is putting the same issue which they have initially recommended. Let's have a look on it again. The maintenance of the CD as a going concern during liquidation led to an escalation of the cost, particularly when the CD has not been sold as a going concern. It is observed that the liquidators seek relief from the adjudicating authority while filing an application for approval of the sale as a CD, even though the same is not contemplated in the code, and this lead to prolonged legal disputes, increased cost, and delays in completion of the process. Another issue is that the reserve price is publicly known, and this is very biggest concern. When a reserve price is publicly known from the first auction, which allow bidder to anticipate price reduction in subsequent auction, leading to strategic delay in bidding and ultimately resulting in lower realization. This is very relevant. This is another issue which is very relevant, that the reserve price is publicly known from the very first auction, which allow every intending bidder to anticipate further price reduction in subsequent auction, and that leads to a strategic delay in bidding and ultimately resulting in lower realization. Often below the liquidation value, removing the option of the going concern sell can help prevent such value erosion and improve creditor recoveries. This is what I believe. For few of the entity, this goes with the intent. An increasing number of cases where the going concern sales are pursued even when the CD is ultimately not viable as a going concern have been observed. And this is what is being witnessed. This has resulted in prolonged delay in the process and lowering recoveries. And that's why there is a proposal, and there was a proposal to omit the provisions relating to sell as a going concern in liquidation regulation. But unfortunately, both have been ended up with. Subclause E, that is selling the CD as a going concern, has lost its place from the regulation 32. Also, selling of the business of the corporate debtor as a going concern lost its way. It is proposed to omit the provision relating to sale of the going concern in liquidation regulation. This change would streamline the liquidation process, reduce legal uncertainties, potentially lead to faster resolution of the case. Furthermore, the liquidation regulation already provide for slum sale. Now, this is relevant. The liquidation regulation already provide for slum sale of the asset. They will continue to address the situation where the asset of the CD need to be sold together for better realization. But the question is, then in that case, will you be able to sell the entire CD? Is a question. This is very relevant. Since the liquidator regulation already provide for slum sale of the asset, they will continue to address the situation where the assets of the CD need to be sold together for better realization. But can you then sell the entire CD or not? Or you will be only positioned to sell the business of the CD. So that was the intent, or that was the idea, ultimate idea of the government, the IBBI, and they put for public comments. And unfortunately, on October 14, 2025, it has been completely, the clause E, that is subclause E and subclause F of Regulation 32, has lost its place from this regulation, that IBBI Liquidation Process Regulations 2016. So, as far as my views are concerned, I will certainly have reference to that as well. But before that, in case still if there is any point of discussion, if required, certainly we can have that deliberation on that aspect before we reach out to the final conclusion, that what the thought process is all about at the end. Does that provision still exist? Does that regulation rather is still exist? Or does the liquidator still have that avenue to sell the corporate debtor as a going concern, because of having that clause under section or clause under regulation 32, which talks about slum cell? And I'm sharing a final viewpoint. I was just reading the the views of several authors, and I found this very interesting. Let me share the same with you. So I was reading the views of several authors, content of several law firms and the IPs, those who have uh, placed their comments on this recent regulations to the liquidation process second amendment regulations, which was there in 2025, that is 14th October 2025. And I found it very much in line with, very much in alignment with what the thought process with regards to this omission, what I hold the thought process. I have seen this is something which is in alignment with what my thought process all about as far as this amendment is concerned. And we can see this. So basically, as far as the IBC is concerned, that deals that ultimate core intent is to maximize the value of the assets of the corporate debtor, and thus the resolution has always been a preferred idea over the liquidation. Even in liquidation, the regulation and the courts have stressed and preferred on selling the entity as a going concern. However, the IBBI wide IBBI liquidation process second amendment regulation has amended the liquidatory regulation, omitting the option of going concern sell through the liquidation process, notably both the options. One, sell of the CD as a going concern, that is regulation 32E. And second, the sell of the business of the corporate debtor as a going concern, that is regulation 32F, have been omitted. So, what impact does this amendment have? Does that mean that the going concern sell is completely gone, or that is now impossible to cause a going concern sell once the liquidation order is passed? Or does that mean that the liquidator have only four options left, that is asset by asset sell, or the sell of the assets collectively or in parcels or in slum cell, but not as a going concern option. Does that mean that if there is already a business which is running, liquidator first have to stop it and then sell the asset? In essence, the business which is live and active will first be killed and sold as a bunch of the asset or the parcel of assets minus the life and the activity. No, this is not. GCS has not gone. So basically, the even though regulation 32 clause E and subclause F of liquidation process regulation has been, or subclause E and F have been omitted, but it is still there. In fact, it was there when the regulations were not amended to include this modes of sale. If the amendment was based on the recommendation of the law committee, the recommendation was based on potential misuse, particularly by selling CD itself, thereby achieving the same result in liquidation that could have been achieved in resolution. Disconnect between the insolvency law committee recommendation and amendment. So before we proceed, it would be important to trace the inspiration behind the amendment. The amendment is pursuant to discussion paper, and this is what we discussed this 4th Feb 2025. The discussion paper apparently quoted the report of the ILC, stating that the liquidation regulation should be appropriately amended to prevent going concern sale of the CD to justify the omission. However, para 5.9 of the ILC report states that the committee agreed that it would be contrary to the scheme of the court to allow the CD to be sold as a going concern after the conclusion of the liquidation process, which envisages a dissolution. However, where the business of the corporate debtor can be sold as a going concern, the liquidator may first attempt the same. Accordingly, the liquidation regulation should be appropriately amended to prevent a going concern sale. Appropriately amended to prevent a going concern sale of the corporate debtor. Therefore, ILC merely recommended omission of sale of the CD, that is the legal entity itself, as a going concern, but not the sale of the business of the CD as a going concern. Surprisingly, the amendment does away with both, disregarding the fundamental difference between two. While the former is selling the activity with the corporate shell, and latter is only the transfer of the business activity and not the shell. Therefore, in the former case, the entity is not dissolved, and the later on stage, it goes away the scheme of. So basically, when the recommendation was only confined to the omission of subclause E to regulation 32 and not F, E deals with selling of the CD as a going concern, wherein the company will continue its existence and the control will be left out from the liquidator in the hands of the willing acquirer or the successful acquirer or the successful bidder. Later on, that clause F of regulation 32 was dealing with selling of the business of the corporate debtor, wherein the assets and liability will be taken over by the acquirer and the corporate shell will be ordered for dissolution. But because of this amendment, both subclause E and subclause F to regulation 32 has been omitted. Amendment does away with both, disregarding the fundamental difference between two, while the former is selling the activity with corporate shell. Latter only transfer of the business activity but not the shell. Therefore, in the former case, the entity is not dissolved. That in turn goes against the very scheme of the code. Nevertheless, we discussed below, even after the omission, the slum cell option make it possible to, and this is what is a part of the discussion paper as well. Slum cell option make it possible to overcome the limitation as is seemingly there. Going concern cell made an entry in liquidation under IBC. In liquidation was not originally there under IBC, and liquidation regulation was only when the Kolkata bench of NCLT in Gujarat NRE Coke order as a going concern cell. That is, going concern cell was first facilitated in liquidation proceeding under IBC. Therefore, even before the IBBI come up with the formal amendment to the liquidation regulation, there were multiple ruling under the IBC permitting going concern sell in liquidation. Here, to answer the question posted above, it would be quite relevant to understand that the context and the fact under which the NCLT order going concern sell. In that case, the CD was going concern and had large number of employees on its payroll. Therefore, the objective of preserving the business operation of the CD and safeguarding the livelihood of its employees, NCLT Kolkata has directed the sale of the CD as a going concern, relying on the provision of section 33(7) of the code, which says that an order of liquidation shall be deemed to be a notice of discharge to employees, officers, and workmen, except when the business of the CD is continued during the liquidation process by liquidator. So, if there is a possibilities when the business of the CD is continued during the liquidation process, still you have this possibility to take the advantage of having existing way under regulation 32, wherein the liquidator may still sell the corporate debtors going concern through that some sell. It was after this ruling that IBBI came up with the discussion paper, and later IBBI liquidation process second amendment regulation 18 was formally introduced in the regulation. Under regulation 32, that is a mode of sell or realization of the asset. While ordering GCS in the above case, NCLT relied on slum sell option from slum sell to going concern, while the two mode of GCS have been omitted. One of the other alternative of the sell is sum sell under clause B of regulation 32 of the liquidation regulation. Slum sell has not been defined under the IBC or liquidation regulation. Therefore, the meaning has to come from the widely referred definition under section 2 clause 42C of the Income Tax Act 61, which define the same as transfer of one or more undertaking by any means for a lump sum consideration without value being assigned to individual asset and liability in such transfer. The definition slum sell relies on the definition of undertaking, for which one will have to refer explanation 1 to clause 19AA of section 42C of the IT Act, which define undertaking as follow. Undertaking shall include any part of the undertaking or a unit or division of the undertaking or a business activity as a whole, but does not include individual asset and liability or any combination thereof, not constituting a business activity. Therefore, an undertaking is a business activity taken as a whole. An undertaking is not merely a bunch of asset and liability. Further, the meaning of undertaking has been discussed in various judicial pronouncements to say and to conclude that an undertaking is a running business and capable of being run as an independent business. Here again, while the definition of slum sell and undertaking under the IT Act may be referred to, however, this should be read in context. That is, in liquidation proceeding, there is no transfer of liability. All liabilities are subsumed under a common hodgepodge called liquidation estate and are paid out of the realization from the same. Also, the IT definition of slum sell is merely about determination of the consideration, not asset by asset, but from the net worth as a whole. The definition is designed from the viewpoint of capital gain determination. Thus, the essence of slum sell is sell of an undertaking commonly undertaken through BTA. As name implies, BTA, the transfer of the business and not the asset of the business. Therefore, slum sell can lead to a sale of the business of the CD as a going concern. However, must be noted that slum sell cannot lead to sale of the CD itself as a going concern, because undertaking is different from the entity itself. So, meaning thereby, if you are still relying upon regulation 32 and selling the assets of the CD as in the liquidation process as part of slum sell, then only you will be in a position to sell the business of the corporate debtor as a going concern and not the entity itself. An entity will be formally ordered for a dissolution. Slum sell is a sale of an undertaking, that is the activity which is housed inside the entity. It cannot refer to and include the sale of entity itself. It may also be noted that every going concern sell is a slum sell. However, vice versa may not be true. A slum sell will be GCS only when the condition exists so as to indicate and include business as. Now, pertinent to question would be, when does one say that the business is and in fact is going? The question is addressed below. So, going concern is another concept. But what I believe is section 33 of the code provide for consequences which shall follow on passing off of the liquidation order. The order for liquidation under this section shall deem to be a notice of discharge of the officer, employee, and workman of the CD, but except when the business of the CD is continued during the liquidation process. Further, section 35(1), which provides for power and duties of the liquidator, says that liquidator shall have the power and duty to carry on the business of the corporate debtor for beneficial liquidation as he considered necessary. Clause E, it is clear from the provision as above that there is neither a presumption nor a prerequisite that liquidation by itself lead to death, otherwise thriving a running business. Just because the CD could not get a suitors during CIRP does not mean it's lifeless. In fact, the liquidator has been cast with a duty to carry on the business for the purpose of beneficial liquidation. As to what is beneficial liquidation, it can be understood as one where the stakeholder stands benefited, which is an obvious outcome of a better realization. Hence, if there is anything which help liquidator in recouping a better value, for that purpose, if the liquidator is required to carry on a business of the company, he shall in fact do the same as it is his duty under the law. In fact, in case of Prakash Chandra Kapoor versus Vijay Kumar Iyer, NCLAT specifically observed that the regulations cannot override the objective. Very important. The regulations cannot override the objective of beneficial liquidation stipulated under the code. Of course, that does not mean that in case where the entity has ceased to be going, that does not mean, again, it's very clear that if the entity ceased to be going, the liquidator shall first revive the same. Therefore, the liquidator order is not the trigger which kills a going concern. The entity might still remain a going concern during liquidation proceeding. And if that is the case, at that time, the liquidator set on to make realization. Is he expected to stop running the business? No. The answer is an obvious no. The wood idea of keeping the business running was to carry out beneficial liquidation. And if the time of selling the liquidator stopped the business, then whole efforts of keeping the business running during liquidation will become futile. That is to say, in simple words, if the business was kept going under liquidation, it can be sold as going. Therefore, GCS, going concern sell, is perfectly possible during liquidation. There is nothing in the code which runs contrary to GCS and liquidation. So, meaning thereby, I still believe, and this is what my viewpoint as well, that though it is not a part at this moment, though it is not a part of the liquidation process regulation, but the idea of the code should not get defeated. Regulation should not overrule the intent of the code. And if there is a possibility that the entity may be kept running, there is a possibilities that a stakeholder may get a better realizations. In that case, any such kind of proposal through which a corporate debtor can be sold as a going concern, or the business of the corporate debtor can be sold collectively as a going concern, what we have seen in regulation 32F, that still can be possible, and there may not be any objection to that effect as well from any committee or from any regulator as well, or from the adjudicating authority itself. So, as far as the entire procedure is concerned, 2018, that was a time when, and there were several orders which were being passed, and that orders were passed in alignment with the rationale of the code to make the maximum realization of the corporate debtor assets, or to have the more realizations rather than having only a liquidation value. But over the period of time, it has now become, or it has become the habit, or it has become a mandatory part of the procedure, that once the liquidation order is passed, it was a liquidator who is inviting a bid for selling the corporate debtor as a going concern. And several entities have been sold as a going concern. The entities wherein the soul itself is not existing, and still the entities have been sold as a going concern, but ultimately the sufferers are those acquirers because of the issues in the assets, or whereabout of the assets. The litigation is still on, because when the entity is being sold as a going concern, the entities are sold as a going concern on as is where is basis. So basically, and again, that is was what later on identified as well, and there was a complete misusage of the CIRP process as well. So when the CIRP has been ended, and the bidders are aware, the applicants, the resolution applicants are aware that the moment liquidation order will be passed, it is the liquidator who will be coming out with this auction notice, wherein the reserve price will be identified. If that fail, there will be a possible reduction. So there will be a strategic delay on the part of the bidder as well. And because of which the valuation of the corporate debtors' assets have been deteriorated. And the stakeholder of the corporate debtor have not even achieved the amount which otherwise could have been achieved during the course of that liquidation if the corporate entity was, if that corporate entity would have been liquidated or dissolved. So that was the overall idea. See, idea of the IBBI while coming up with this kind of, you can say, regulation was very clear, and that was again to maximize the valuation. But the way the procedures have been made, rather than this options have been, or this was not being picked as a selective tool, जहां पे जरूरत है वहां पे the corporate debtors have not been sold as a going concern, but it was form, or it was considered as a part of a routine process, that first the liquidator in all the circumstances, even though there is no possible life to that corporate debtor, even though this corporate debtor will be sold as a going concern, there is no possible way through which the entity can be continued as running. But still every attempts are being made, or every attempts have been made by the liquidator, in spite bringing no additional value to the life or to the assets value of the corporate debtor. They have started this, or they have initiated this process of selling the corporate debtor as a going concern. So considering those misusage, considering those strategic delay, and very rightly identified in the discussion paper, there is nothing like a relief and concession in the code when a person is opting, or a liquidator is opting for selling the corporate debtor as a going concern, or bidder don't have such kind of concessions or relief which is forming a part of the code itself, but still those reliefs and concessions have been made as a part of the relief, or made as a part of the applications and petitions which were being filed for selling the corporate debtor as a going concern. So something which was there in the regulation, not in the code, and the same were being utilized and the same were being practiced, and later on, with effect from 14th October 2025, it has been done away with. So that's all. Today we can say that prima facie it is not there as a part of the regulation. When we see the IBBI liquidation process regulation, but particularly after second amendment regulations 25, with effect from 14th of October 2025, it is done away with, it is gone away with. It's not a part through which a liquidator has to first decide that let's sell the corporate debtor as a going concern, or let's sell the business of the corporate debtor as a going concern. So now it will be evaluated, the situation will be evaluated, it will be monitored, and then it will be decided that under the banner of selling or realizing the assets value through slum sell, can the business be sold out as a going concern or not. So idea is very clear, the intent was very clear, the rationale was very clear with regards to insertion of this sub-regulation E and F to regulation 32, and rationale is made more clear while deleting and omitting sub-regulation E and F from regulation 32. So this can be identified from both the discussion paper. Yes, if any views are there or any of the questions are there to be discussed, first that need to be addressed. I will invite views, I will invite suggestions, I will invite questions, I will invite your opinions, I will invite your experience, I will invite your say in the subject before we formally conclude this. And that was informed that considering the life of the subject, or considering the end which is brought in by the second amendment of liquidation process regulation, the discussion will be confined to how it was brought in, what was the rationale with which it was brought in, with what rationale it was proposed to be omitted, what was proposed as omitted, and what has been omitted therefrom, and how I still believe that it's still a part of the liquidation, or it's the liquidator's duty to see and to keep the entity going concern if it is permissible, or if the situation demands the corporate debtor to be running or to be continued. So that was what the viewpoint is all about. In case if there is anything to be discussed, anything to be deliberated, we can firstly take up that before we formally conclude the session. Anjali, if you may please check out with the participants in case if they want to place before or put forth any questions, they may unmute themselves or they can place their queries in the chat box so that we can take it on the basis of their sequence of the questions. And if there is no question, we can formally end to the same discussions. I believe there is no concerns or concerns, if any, are not being put forward. But this is what the law is, this is what the regulation is, and I must believe that the litigation is never going to be, or this is not, and this is very important, that all the process which were running as on 14th October 2025, that will be continued. So it has not given any retrospective effect, it is having its prospective effect. So no such kind of, you can say, and direct attempt to selling the corporate debtor as a going concern with effect from 14th of October 25, but otherwise the procedure which were incomplete or which were in process, that will be continued, and those entities will be continued being sold as a going concern. I would like to extend my thanks to all the participants for patience during the course of hearing, and I'm thankful to the institute as well for giving this an opportunity to deliberate and to discuss on this subjects, the part which is recently omitted, to see the critical part of it, the rationale behind the same, and how still the same can be survived. So it was the viewpoint, and certainly there will be more problems which may be created, especially for the entities which are still having some life pending. But because of these omissions, they may not be come out, or the liquidator may not be confidently come out with this proposal of selling either entire CD as a going concern or the business of the CD as a going concern. Thank you very much.
बेसन तो ले आई दीदी कल Thank you all the participants for giving your valuable time and attending this